My name is Matt Weidner. I practice law in St. Petersburg, Florida, and I spend my time defending consumers from the abuses of banks and institutions. I've done it for many years now, and that's my day job. But today I'm doing a public service. I want the American people, I want you and you and you and all of you to understand one of the greatest tragedies that's happened to the American people. It just happened recently. You might have heard about it in the news. It's called the National Mortgage Settlement. Now, the news may refer to it as the National Mortgage Settlement, but I'm going to refer to it by what it should be called, and that is the National Consumer Sellout. Because all the consumers, taxpayers, all across this country have been sold out in a conspiracy between our federal government, our state governments, and the banks and institutions. And you know, one of the things that really disturbs me about what's happening in this country is that the tragedies that are occurring to American people, the abuses that we're suffering, are occurring right in front of our very eyes. And the American people are not doing their job in finding out the information and paying attention to what's happening in this country. Now, you're not entirely to blame. You see, we rely on the news media to report the news, but as we're going to learn here in the context of this national mortgage sellout, the news media has not done their job in explaining to the American people exactly why it is that this is such a travesty, such a robbing, such a gutting and thievery of the American people. It's important that you be able to be a sophisticated consumer of information that you find on the internet. It's important that you as a consumer know where to look for correct, accurate, and verifiable information. So as I go through this sellout today, I'm going to be pointing you to first source information. That's something you need to understand. First source information is not information that is untrustworthy or unreliable. First source information is going directly to the source. And in this case, the source that we're going to be relying on are the documents that have been released by the federal government and the state attorneys general, and we're going to be exploring the documents and examining them very carefully. Now, I encourage you to spend a little bit of time with this. You're going to come away with a much deeper and frankly, a much scarier understanding about what's happening in this country. Now, the first document you're going to pay attention to is found at the website, and we'll put it up here, the National Mortgage Settlement, where you're going to pull up the documents I want you to refer to. Number one is the complaint that's found on this website. That's the first document. The second document that I want you to download can be found at the Office of Inspector General website, and again, that website address is here. On there, you will find reports that have been produced by the Federal Office of Inspector General. These are audit reports where they actually went in and examined what was occurring at the banks and institutions. So I want you to take these two documents, go onto your web browser, download at least one. In this case, we're going to be focusing on Bank of America. Go to the Office of Inspector General and download the Bank of America Office of Inspector General Audit Summary, number one. Number two, go to the National Mortgage Settlement website and download the document that was filed in federal district court that outlines the terms of the $25 billion settlement. Now, I began the discussion by saying that the National Mortgage Sellout is a conspiracy between the federal government, and we'll have that represented here in my description as a... That's the White House right here. I promise you I'm a better lawyer than I am an artist, but you'll just have to make do with that. I'm going to do my best to draw the United States of America. That's even worse, I know, but trust me, that's Florida right there. And then over here, represented by this, we're going to draw that as the banks. Now, the important thing I want you to understand about the National Mortgage Sellout is it's a conspiracy between the White House, the banks, and the 49 state attorneys general that signed on to this agreement that I want you to examine that sold out the rights and interests of the American people in favor of the banks and institutions. Now, understand, folks, the National Mortgage Sellout has been described in the press as a settlement of robo-signing practices. We all know what robo-signing is. It's a term that was born in 2010, correctly or not. I'm given some credit with coining that phrase in the Wall Street Journal. Robo-signing was indeed part of the National Mortgage Sellout, but the fact of the matter, and this is the most important point to take away from this, the National Mortgage Sellout or Settlement Agreement was the settlement of the largest insurance scam in the history of mankind. What we're going to demonstrate here is that the claims that were being prosecuted by the 49 or 50 state attorneys general really had little to do with the robo-signing practices, but the fact is that the real claims behind the sellout have to do with the false insurance claims that were being made by the banks and institutions. Looking carefully at first the National Mortgage Sellout complaint that could be found on that website, if you want to print it out, I think that's important, start printing at page 14 because the first 14 pages are nothing but the states on there. But the real meat and potatoes of the National Mortgage Sellout complaint begins at page 14. The reason it's important for you to print out the National Mortgage Sellout complaint is this complaint lays out in very clear and concise terms exactly what's occurring with the national mortgage market or real estate funding system and foreclosures. We hear a lot about federally insured loans. We hear about foreclosures and the banks and institutions, but frankly, even for sophisticated practitioners, we don't understand how all the pieces put together, but this lawsuit lays it out pretty clearly. There are, in fact, a total of 5 separate areas are important to focus on that are described in this complaint. The first has to do with the fact that the banks and institutions, when they originate loans, do so with the full faith and credit of the federal government. They're paid to go out and originate loans. When we hear conversations about bad borrowers, we're not taking into consideration the fact that the reality is the banks and institutions that made the loans were the ones in the stronger bargaining position, and they made the decision to make those loans to the quote-unquote bad borrowers, not the homeowners. Many times, the homeowners are unsophisticated. They relied on representations of the federal government, the banks and institutions, that getting into these loans was a good idea, and that in fact they would refinance the loans or get out of it once the economic conditions got better. And we assumed when most of these loans were made in 2006 to 2008 that things were going to get better. So we need to get away from talking about bad borrowers and understand that the crisis that we find ourselves in with mortgage finance has to do with the incentives given to the banks and institutions by the federal government to make loans in large volume to consumers all across this country. So the first thing to understand, is laid out on page 14 of the complaint, is a description of how the incentives were provided to the banks and institutions by the federal government to go out and make loans. The second component is that once they made those loans, the banks and institutions were supposed to service them and collect the payments according to very strict guidelines. Like the origination of the loans, on the second part of it, the banks and institutions were required to service and take care of these loans in very strict and specific ways so that they were managing the loans properly. We're going to show throughout this that, in fact, they didn't originate them properly, they didn't service them properly. And then here to number 3. After the loan was originated improperly, after it was serviced improperly, and third, now that they were in modification, as a condition of being a direct endorsement lender, as a condition of making these loans to consumers, the banks and institutions were required to engage in loan modification programs with consumers. Okay, so one of the things I wanted us to focus on is that when we're examining the national mortgage sellout, we need to understand that the federal government, primarily through FHA, the Federal Housing Administration, provides very specific rules and regulations that the banks and institutions should have been following at the point in time when they originated loans, when they serviced loans, and number 3 here, when they modified loans or where they were trying to rehabilitate loans. Now, I want us all to think back to 2008. We recognize we were in the middle of an economic crisis, and the federal government and state governments, but primarily the federal government, was engaging in dramatic programs to try and save the country, if you will. So, beginning at page 18 of the National Mortgage Sellout complaint, you'll see that we have a dizzying description of programs that the federal government put together. We've got TARP. We've got MHA. We've got HDPD. We've got PRA. I'm not even going to bother with you having to read those things. The point of it is to understand that beginning on page 18, 19, and 20, we see all of these different programs that the federal government rolled out that the lenders were supposed to be examining each file to see whether the loan could be rehabilitated. Now, most of these programs provided incentives for the banks and institutions to try and fulfill their requirements under the FHA guidelines. But what the complaint lays out in very clear and direct terms is the fact that despite the fact that the banks and institutions were collecting money from you and me, the American taxpayer, they were not servicing the loans appropriately, number 2. They were not modifying them, number 3. And they were not utilizing the programs with these dizzying array beginning at page 20 that they should have been engaging in. Page 21 details all of this with specificity, so that if you look at page 21 of this complaint, you will see that, and I quote, "The banks engaged in unfair, deceptive, and unlawful servicing processes." It says, "The bank's unfair and deceptive practices in the discharge of their loan servicing activities include, but are not limited to, failing to timely and accurately apply payments, charging excessive or improper fees, failing to properly oversee third parties, improperly putting forced place insurance on. So again, at the second phase right here, what the complaint lays out are accusations that the banks and institutions engaged in improper practices in the servicing of these loans. The complaint goes on then to lay out the banks and institutions engaging in improper practices and procedures when they are modifying the programs. Keep in mind, folks, that at each step in this process, the banks and institutions are getting your dollars from the federal government. Now, you didn't get a say-so in this matter. The federal government's busy collecting your dollars and then siphoning it off directly to the banks and institutions, but they're not holding them accountable as they would you and I. And that's one of the things that I want Americans to consider and understand as you consider the moral, ethical, legal, and social implications of foreclosure. The social implications and legal implications of foreclosure are that we've got bad borrowers on one hand and good borrowers on the other hand. But an unsophisticated analysis doesn't take into consideration the absolutely reckless, improper, potentially criminal conduct of the banks and institutions that got us into this foreclosure mess that we're in. And the reason why this lawsuit is so important to understand is this lawsuit, this complaint details the allegations that were made by our attorneys general. Now, theoretically, the attorney generals work for the American people. But the fact of the matter is that what this settlement reveals is that the attorneys general are busy working for the banks and institutions to placate them and figure out a way to give them more of our money. When we focus on number 3, I want you to pay attention to page 23 of the National Mortgage Sellout, because likewise, just as the complaint lays out servicer irregularities and improper conduct that the banks and institutions engaged in the servicing component of their responsibilities, the lawsuit also lays out, beginning at page 24, the improper conduct that the banks engaged in at the modification level. And again, it says that the bank's failure to discharge their required loan modification obligations and related unfair and deceptive practices include, but is not limited to the following: failing to perform loan modification underwriting, failure to gather or losing loan modification documents, failing to provide adequate staffing to implement programs, failing to adequately train responsible staff for loan modifications. I want every consumer out there who went through submitting loan applications, loan modification documents to their lenders and institutions to pay particular attention to page 24. You know, for years, consumers came into my office claiming that they had submitted loan documentation again and again to try and get loan modification, but that the banks continued to request additional information to claim that they hadn't received bank statements or tax returns or any of the information the consumer had submitted. And as we see on page 24 of the National Mortgage Sellout complaint, it seems that that was true, that the banks and institutions were not accurately staffing their organizations and they were not adequately processing loan modification applications. Keep in mind, however, that at each step in the game, even though they were not adequately fulfilling their responsibilities to the American consumer in considering loan modifications, they were in fact collecting money from the federal government. Another key point is that at the same time they were convincing consumers that they might qualify for a loan modification, they were also continuing through with the foreclosure process. So on page 25, it asserts that the banks were misrepresenting to borrowers that loss mitigation programs would provide for relief from the initiation of foreclosure proceedings. That in fact was not the case, but there is in fact allegations out there that the banks and institutions were convincing consumers, don't make your mortgage payments, engage in the modification program, while at the same time not advising them that they were still subject to foreclosure proceedings. Now, the fourth stage in the improper conduct that was engaged in by the banks begins on page 26, and that is improper foreclosure or bankruptcy related proceedings. You know, once they did not properly originate the loan, and then the bank didn't properly service the loan, and then they didn't properly engage in the loss mitigation programs that they were required to under FHA and federal requirements. Number 4, the banks and institutions have been engaging in gross and improper practices in foreclosure proceedings all across this country. And as an attorney that practices in foreclosure law, the fact that the banks and institutions are alleged to have engaged in improper practices in our courtrooms all across this country disturbs me more than about anything else. As the complaint lays out, the accusations against the banks are that they engaged in improper practices in foreclosure proceedings and in bankruptcy proceedings. Let me read for you one portion of this. On page 27, it says that in the course of the conduct, management, and oversight of foreclosures, the banks have engaged in patterns or practice of unfair and deceptive practices. That includes preparing, executing, notarizing, or presenting false and misleading documents filing false and misleading documents with courts and government agencies, or otherwise using false and misleading documents as part of the foreclosure process. Understand this, people. In this complaint, it lays out what defense practitioners and consumers have found all across this country, and that is that the banks and institutions are engaging in false and improper practices in our courtrooms. And they're getting away with it. They continue to get away with it now, even more that this settlement has been reached. Now, another component of this fourth element here, the bank's improper conduct in foreclosure proceedings, is the bank's improper conduct in bankruptcy proceedings. Beginning at page 34, the complaint here lays out the allegations that the banks engaged in improper practices in our federal bankruptcy courts. Now, I want you to understand the full impact of this. What's laid out beginning on page 35 is, as a result of the use of inadequate bankruptcy procedures, the conduct of the banks or their agents has resulted in, among other things, some or all of the following: making false representations that were inaccurate, misleading, false, or for which the banks at the time did not have a reasonable basis to make. Number 2, filing false proofs of claims, motions for relief of stay, or other documents that fail to include documentation required under the federal rules of bankruptcy. Number 3, filing lost note affidavits for which the banks at the time did not have a reasonable basis to make. And finally, filing false proofs of claim. Now, folks, I want you to understand something here in this fourth element. What the complaint lays out is that the banks and institutions engaged in false, deceptive, and misleading conduct, and that they did that in our courtrooms. They did it in state foreclosure proceedings, and they alleged to have done it in bankruptcy proceedings all across this country. Now, folks, if the banks and institutions are allowed to get away with the improper practices in our federal bankruptcy courts and in our state courts, what might they not be able to get away with? And again, that's the thing that I find most disturbing. The complaint lays out in very detailed form how the banks and institutions allegedly engaged in improper conduct in our court system, and they've been allowed to get away with it. Now, folks, I began this video talking about the fact that the national mortgage sellout was not primarily about robo-signing, although that was certainly bad enough. I asserted that the national mortgage sellout was really about the largest insurance fraud scam that had ever been perpetrated on a people in the history of mankind. And that's where we get here to the fifth and final element of this. Paragraph 5 lays out what is in fact the most compelling part of this entire national mortgage sellout. When the banks and institutions originated loans using the full faith and credit of the United States government effectively through FHA guidelines and requirements, they originated what are federally insured loans. Now, federally insured loans mean that if a loan goes bad, the federal government, that's you and me, that's our taxpayer dollars, are going to pay for that loan to make it better. And that's why this fifth element is so crucial. The banks and institutions have fleeced the American people at each of the 5 steps that I've indicated here. They fleece the American people at originating the loans. They fleece the American people when they're servicing the loans. They fleece the American people at modifying the loans. They fleece the American people in bankruptcy and foreclosure courts. And fifth and finally, where the banks and institutions make claims on the federal government, that's your taxpayer dollars, to pay off bad loans when they could have been servicing them properly, modifying them properly, or engaging in proper practices in our court proceedings. But they're not. One of the things that we're all focused on now is how many new foreclosures are being filed. Nobody's paying attention to what happens to foreclosures at the end of the day when the foreclosure sale happens. One of the most disturbing phenomena is the fact that the banks and institutions are preventing third parties from bidding at these properties at publicly held auctions so that they, the third parties, can take title to the property. I believe part of that has to do with collecting additional insurance money from the FHA. But the fact of the matter is that the general public needs to take a much greater interest in what's happening to foreclosure proceedings at the end of the process, when the foreclosure is concluded, when the public sale is happening. We're ignoring that. Nobody's paying attention to that. But what we need to understand is that the banks and institutions have fleeced us all at every step of the way, and the final fleecing occurs at the end of a foreclosure or end of a bankruptcy proceeding when they make still more demands on taxpayer dollars in the federal government. Now, the second document that I want you to pay attention to is the Office of Inspector General reports. What happened was the Office of Inspector General went out and audited some of the servicers that are engaging in improper practices across this country. What I find most compelling about the Office of Inspector General reports, and the website is linked directly there, I want you to click on that link and I want you to download a couple of those. In particular, I want to focus on the Bank of America Office of Inspector General Corporation report. One of the things that's most disturbing is the fact that the banks and institutions are able to make extraordinary claims on the federal government. That's, again, your taxpayer dollars. Keep in mind that Bank of America alone, according to this first page of the Bank of America Auditor General report, was that during fiscal years 2009 and 2010, it submitted 36,095 FHA claims totaling $5 billion. Let that sink in for a minute. During 1 year, the Bank of America submitted claims to the FHA totaling $5 billion. That's an important figure to keep in mind as you consider all the headlines about this $25 billion settlement. This one audit report alone shows that Bank of America submitted extraordinary claims, $5 billion, that they wanted you, the American taxpayer, to pay. After the banks, and in this case Bank of America, are submitting claims to the federal government asking you or I to pay them for the loans gone bad, you think that when the federal government comes knocking at your door, the Office of Inspector General with that big scary logo on there, you would feel compelled to provide information. I know as a taxpayer or a citizen, if the federal government made a demand on me, I would certainly be complying right away. But one of the things that I find most disturbing about these audit reports is they describe how the banks or institutions were able to ignore the requirements, ignore the investigations that the Office of Inspector General were making. I'm going to read from page 2 here. From the beginning of a review in October 2010, Bank of America limited our access to employees' information. Ladies and gentlemen, the banks and institutions are able to ignore these subpoenas, are able to ignore and frustrate the investigations of the federal government into the improper use of your taxpayer dollars. I find that most disturbing. They're giving away hundreds of millions and in some cases billions of dollars in taxpayer dollars. And when the federal government goes to try and audit them and find out the legitimacy of these claims, they're able to tell them, we're not going to participate in your investigation. On page 3, although we repeatedly requested policies and procedures in effect during the entire review period, Bank of America would provide only those that generally became effective October 2010. And then Bank of America provided incomplete data which impeded identification of all affiants, notaries, and attorneys in the investigation. Understand what happened here, folks. The federal government came knocking at the door of these banks and institutions, and the banks and institutions told them, we're not going to cooperate in your investigations. We're going to frustrate your investigations. So one of the things that's so disturbing about this settlement is it's based on incomplete information. Understand that according to page 3 of this Office of Inspector General report, the report on Bank of America is based on a statistical sampling of 118 Bank of America claims. Understand this, folks. A settlement involving hundreds of billions of dollars of FHA claims is based on a sampling of only 118 files. I find that most disturbing. Likewise, I find it disturbing that the investigation of Bank of America began, and I quote, with our review on October 15, 2010, and performed on-site work at Bank of America's offices in Fort Worth between October 2010 and January 2011. I want you to understand something, folks. The investigation of Bank of America and the settlement that would be reached under the terms of this, according to this report, occurred between October 2010 and January 2011. And it states, our review was significantly hindered by Bank of America's reluctance to allow us to interview employees. When interviews were permitted, the presence or involvement of attorneys limited the effectiveness of those interviews. The presence or involvement of attorneys limited the effectiveness of the interviews of the federal government that was investigating what was happening with your taxpayer dollars. On a number of occasions, Bank of America's attorneys refused to allow employees to answer questions, stopped them in the middle of clarifying information already provided, or counseled them in private before allowing them to provide a response. Further, Bank of America would not permit an effective walkthrough of its document execution process that would have facilitated an understanding of its process. And a chilling phrase here, folks. As a result, it was not possible to know how much information Bank of America omitted that was relevant to our review. That's on page 4, folks. The Office of Inspector General, the federal government investigating Bank of America, states in here clearly that they were not able to determine just how big of a problem it was because they were hindered in their investigation of determining what happened with your taxpayer dollars. Ladies and gentlemen, the purpose of this video is to encourage you to wake up, to get involved, and to pay attention to what's happening in your country. The foreclosure crisis that rages across this country is a symptom of the much larger cancer that's eating at the very heart and soul of this nation. What's happening in our neighborhoods, on our streets, to our neighbors, is a devastating desecration of Americans' basic principles and values. Our court system is under attack like never before by the banks and their improper practices and procedures. Our communities are under attack like never before. Your neighbors are suffering like never before, and they're suffering at the hands of the banks and institutions that we rescued, that we protected, that we preserved, and yet they're turning against us. They're turning neighbor against neighbor, community against community. The purpose of this video is to encourage all of you, every American, to go beneath the headlines of your local news and your newspapers, to read these documents carefully, and to consider the profound implications of a national mortgage sellout that in fact is a sellout of the American people to the tune of billions of dollars. I want to encourage every single one of you, when you hear the word foreclosure, to take a more sophisticated understanding about what's happening in this country right now with the banks and institutions being pitted against the American people. Right now, the American people are taking it on the chin by the banks and institutions that we rescued, that we preserved, that our federal government protected. The national mortgage sellout is in fact a sellout, and it's a desecration of basic American values. We as Americans need to stand up together and to support our neighbors and communities all across this country. We need to support our court systems and our judges that are in fact defending Americans and defending the basic rule of law. Most importantly, you need to fight every foreclosure. Far too many of them go undefended. So that's my message to you. Get involved, read these documents, take a far more sophisticated understanding about what's happening in this country.